All right, our next topic that was submitted was by Lieutenant Plowman with the Commercial Enforcement Mix-Up Commander of the Nevada DPS Highway Patrol. Lieutenant Plowman is a 20-year member of the Nevada DPS, and prior to his current position, he served as a sergeant, primarily as a commercial enforcement operations supervisor, as well as a traffic enforcement operations supervisor. And he had hoped to join us in person, but unfortunately had to change plans and join us virtually. And so, Don, if you'd like to go ahead and talk about some of the legislative changes that are going on in Nevada related to the legalization of marijuana.
Yeah, sorry I couldn't make it. My goal with this presentation was kind of to, elicit some information from this group, because it's a great group. I attended the last one and there was a lot of good information, and, hopefully use that, to offer as suggestions to our session. But like I said, everything's been moving so fast that we're really deep into this. And so I know this topic's been talked about many times, and but in Nevada we've had some changes lately. We legalized back in 2017, but it didn't really change anything because our DUI laws stayed the same, simply because we were an implied consent state. Last time I attended the summit there in Denver, there was quite a few presenters that talked about it, and one of the great things they talked about was the funding from the marijuana taxes that they got, and how it really kind of helped out their state and the state agencies and whatnot. So I was pretty excited about that because Nevada, the first thing that usually goes is our state employees will get furloughed or we lose step increases, and it creates a retention problem for us. So I was pretty excited about it. And honestly, I was a lot more excited about legalizing weed in Nevada than I was that we decided to give the Raiders a home here in Nevada. But like I said, our current session, it's being held virtually. So the transparency and the communication of this is not very good. And it's created a lot of challenges and some really unexpected changes. And one of our assemblymen, he proposed a bill that would eliminate the illegal per se limits as it relates to marijuana. And this bill was discussed on the Thursday in their session. It was approved on that following Saturday to be heard the next Monday. So it created quite a panic for everyone. Okay, so this is our current law here in Nevada. It has all the bells and whistles. You can't be under the influence, 0.08. It has the 0.04 for commercial vehicles in there. Can't be under the influence of a controlled substance. So we're good in all that part. So here's our illegal per se's. So we have two DUI laws, which I'm sure is similar in every other state. They're identical. One just pertains strictly to commercial vehicles. The other one is non-commercial vehicles. You can see we're at 2 nanograms, which is that's relatively low. There's a few states that are actually lower than that, but we were able to maintain a level of safety at that level. They took out the urine level because for whatever reason they didn't feel the testing was appropriate. But if you look at those nanograms for urine that are in our law, those come straight out of Part 40 of CFR, and those weren't meant to be an impairment standard. That was just meant to flag a positive result. So it's kind of interesting that we went with that, but then we created our own nanograms for blood. So we were kind of good there. So here's what our assemblyman proposed to do. He wanted to take out he just wanted to strike the marijuana out altogether. And he just wanted to create an impairment standard. So basically what it would mean is that, a defendant has to show signs of clear intoxication and impaired to the point where they cannot operate a vehicle safely before they could be any kind of law or arrest or any kind of sanctions could be taken against them. And his reasoning was he wanted to discourage officers from making marijuana arrests based on the presumptive levels. Because he felt like, at a 0.08, if somebody's at a 0.08, they're going to be convicted regardless because they're at the illegal per se limit. And so he feels like getting rid of this would allow that defendant to get on the stand and offer some sort of testimony or rebuttal evidence to prove that they were not impaired on the day of that arrest. He had a lot of testimony for from science-based, saying, the marijuana impairment is arbitrary and it can vary from person to person. And there was quite a few people that discussed that. And then finally, he really felt like it should be the same standard for prescription drugs like Xanax or, any of the narcotic analgesics, where there are no per se limits, but they can still be arrested for DUI if the circumstances exist. Okay, so what we were concerned about it because it would create a gap between the 2 nanograms. So now we're creating a complete impairment standard to where, they have to show outward signs of complete impairment before they can operate that vehicle. And, that's in contradiction to federal law, because they can't have any in their system. And so we felt like it's going to create too much of a gap. What are we going to do in that interim part? And that's kind of the way the bill was written. So it wasn't very, but they weren't thinking about commercial vehicles at all, to be honest. Then when you strike out the marijuana, it gives a false inference to commercial drivers that it's okay. And you would think that these drivers do know, and I believe they do. However, our judicial outreach officer is one of them in Las Vegas. I think he's on the call. I've spoken with him, and he's told me several times with drivers, he has to show drivers in the regulation where it's illegal for them to be under the influence of marijuana. And then we were worried about, would it have an effect on our MIXAP funding or DMV because they're our licensing authority for state funding. We just weren't sure. We didn't know what the impact would be because this, like I said, this happened really quick. But the most important thing is we're worried about the safety of the motoring public. You can't, giving that kind of standard all the way up is dangerous, especially when you're talking about 80,000 plus pound vehicles. And so we felt like this would have a negative impact on safety. So our immediate response was, like I said, this came out on a Monday. That's my day off. I was getting calls left and right. I was told, hey, you need to contact the director of the DMV. I contacted her. She's like, hey, this bill is going to be heard in 30 minutes. I need you to testify. And I was still in my pajamas because it's my day off. And I was like, okay. I mean, that's just how fast things were going. And so luckily it wasn't a Zoom call because I wouldn't have had time to get ready for that. But it was just over the phone. And, so really all I just talked about is, the 392.4, the prohibitions are not allowed to have any, they can't use it, be under the influence of it or possess it. Then I talked about the difference between a 4,000 pound vehicle crash versus an 80,000 pound vehicle crash. I mean, I think Chris Turner showed a few pictures yesterday of what can happen in those situations. And then we stressed the fact that marijuana is a Schedule I substance at the federal level, and CDL holders, they're subject to those regs, so they need to be held to that standard. And then we discussed the impacts of grant funding. Like I said, we weren't sure, but we asked for the ability to work with them and try to come up with an amendment for the commercial side of it. And they appeared open to that. So from there, we and Captain Hahn just discussed it. Working with your NTA, we have a great relationship with our NTA. We're blessed to have Bill Bensmiller and Jared Calderon from FMCSA as our state administrators. They work with us. They help us out in anything. They've been instrumental throughout this process, giving us the guidance that they can and helping us out. But beyond that, we just have a great relationship, and it really does make a big difference when you're trying to tackle something of this magnitude. And so we discussed it, and we thought, well, okay, this is going on so fast, so why don't we just see if the director will leave, or the Assemblyman will just leave the commercial regs the way they are, because it'll keep us in compliance for right now. And so the DMV director, she sent out an email to the Assemblyman requesting that, and I should not have been included in his reply thread because it was not pretty. I mean, he was rather rash with her, I will say that, but she handled it quite well. When she replied back, she just said, I don't think he likes our proposal. So we were kind of dead in the water. So we were like, how do we sell it to him that, commercial CDL holders need to be held to that different standard? But he said he would entertain another amendment if one was offered. Okay, so these are kind of the considerations that we had. We have laws related to minors. I'm sure most states do. If they're a .02, they lose their license. It's just the way it is. Driving is a privilege, not a right. So we brought that in, and we looked at the .04. He's talking about an impairment standard. And I was like, somebody that's at a .04 is probably not going to exhibit enough clues on field sobriety tests to actually say they are impaired. There's too many factors with it. And I did many years of DUIs that, somebody at a .04, they just don't show that. But nonetheless, it is against federal regulation. So it's in our law. So it was no problem. So, I want to kind of emulate that type of thought process. Then we wanted to look at the drug and alcohol clearinghouse data, and Administrator DiLorenzo showed it yesterday. I actually had that same slide in this presentation, but it's concerning, that what's going on with marijuana. And then we wanted to review the intent and the purpose of the federal regulations. We wanted to impress upon them that CDL holders, they cannot perform any safety sensitive function if they test positive for a controlled substance. And arguably, operating in a commercial motor vehicle would be the most safety sensitive function that they can perform. So on the roadside, we really need to be able to have the tools to take care of that. And so we were able to set up a Zoom call with the assemblyman to try to discuss these things and see if we could come up with something more friendly and something germane for his bill. But during that conversation, he had said he didn't believe the bill was going to make it to the Senate. So he kind of said, but if it goes, we'll discuss it. So it was a great call. We didn't think it was going to go anywhere. I thought, great, I'll be able to get some input because this is going to come back. If it didn't make it through this session, it's going to come back. I'll be able to offer them some feedback from this group and deal with the lessons learned from other states. But in similar fashion, on a Tuesday, I got word that on Wednesday it was going to be heard in the Senate, and we didn't have any time to prepare or anything. So when I had a presentation set up for that assemblyman, if we were going to go that far during that Zoom call, but we didn't get to go with it. But so I wanted to show them the clearinghouse. Any way you slice the data, whether, we know it's been a problem before. This has just been collected since January 6th of last year. It's clear that marijuana is a problem. It's the biggest problem. So we understand that this will be able to show them, hey, there's something going on. Then I just wanted to show them 392.4 so you could read it. And I highlighted the NE 21 CFR Schedule 1 substance because basically what we're getting is he didn't want to say you couldn't use marijuana. So I figured if we could get this part into law, then we're saying marijuana without saying marijuana. And that was going to be our pitch to him in that regard. And this was like the most pivotal one to try and show him, that the .04 was never intended to be like a DUI statute for the states. It says it right here in the statute that it was more about licensing sanctions. So that's kind of what we're trying to draw from. Is like, hey, I agree that somebody should be to convict even a commercial driver of DUI. Yeah, they should exhibit those signs, but they are federally regulated, so they shouldn't have anything in their system. So using the spirit of this particular regulation, I said, this shows that, hey, the feds want you to take licensing sanctions because we don't want to wait till something bad happens. They want to get it before it happens. And that's the only way to do it. And then I highlighted at the bottom there, states shall be deemed in substantial compliance. And, that was my pitch. Like, why be in compliance when we can be in substantial compliance, And further with this actual law, everybody thought it was just they just cut it in half, but that's not true because when that Safety Act came out, the legal limit federally, even in this state, was a .10. So this is what they agreed. Said, hey, if you're at this level, you're beyond following regulations. But it wasn't meant to be a DUI. So then we looked at convictions. I think most states have the same setup. I've had many DUIs where it gets dismissed in court or reduced, whatever. But in DMV, they still lose their license. It's two different courts. It's administrative. So we were exploring the idea of kind of trying to set up that. However, with this particular case, with masking, that there wouldn't be any room for a dismissal or a reduction because it would just create too many problems. But you have to have a criminal nexus here in Nevada before you can trigger the administrative part. So, for example, for our trip permits, if anybody doesn't purchase a trip permit before they come to the state, if we don't write that citation, then there's no criminal nexus to it. So DMV can't go after them. But if we write that citation, they can take that criminal information and assess an administrative fine for it. So this one, I just wanted to show them that, to emulate the point that the .04 is a standalone. So you have DUI alcohol, you have controlled substance, and you have the .04. And so anybody that's DUI controlled substance should be there, and anybody that's not DUI per, the impairment standard should still be fall under that for licensing sanction purposes only. So we wanted to adopt a zero tolerance for CDL holders who are operating CMBs. And I wanted to insert the language from 392.4, like I said. The illegal safer limits were kind of silly because to make a zero tolerance standard, you just need to get rid of all of those. They can't have anything in their system. So any detectable amount, we need to have the ability to take licensing sanctions on them. And we had to do a little bit of work on our implied consent, which was no problem. That way we could still take them in if we have probable cause to believe they were under the influence to any degree. And then we really wanted to push home the fact that DMV can take licensing sanctions either through the criminal conviction or through an administrative conviction. And the same process in consideration for the minors and the .04 standard. So what happened is when we found out on that Tuesday, met with the DMV director, and we didn't have any time to try and prepare for this. And at like 3:30, we have a conversation, and I just pitched all this stuff to her. So this is what I think we should tell him. And it was really a Hail Mary. And I didn't know how it went. I didn't hear anything until I actually watched the hearing the next day. And this MMN actually, he bought off on all of it. And so this was written by his staff member to present to the Senate. And it's putting in there that, we can take administrative licensing sanctions at the .04, but less than 0.08, or any detectable amount of a Schedule 1. So here's the new law, proposed law. I'm able to say marijuana without saying marijuana. And then they added this they took out all the implied consent. So he agreed with that. Took out not the implied consent, sorry, the per se limits. And then he added this, we added this provision for licensing sanctions because Nevada's laws were a little bit different. We didn't have a disqualification other than our adoption in law. So we put it in law. And then this is the addition to that particular law, just to make it to allow for it for licensing sanctions for even the .04 or detectable amount. Now they do have a period of 1 year in there, which I've already discussed that with them. I was like, we can't put that because if it's a multiple offense, there's different prescribed time limits in 383.51, but they said that part will be real easy to fix if it makes that far. And so where we're at today with it is it did pass through the Senate. It's now sitting at the Senate Finance Committee. We have 5 days left in our session. So I'm not sure if it'll make it on the full agenda. I honestly don't see why it wouldn't. And but if it doesn't, it gives us a base ground for next session and say, hey, this is what we need to do. And then we can work on some other things. But if it does pass, I think we've accomplished enough. It's not what everybody wanted. I feel like that standard should apply to all drivers, not just commercial drivers, but I'm the commercial commander, so I got to take care of my shop and do what's right in that regard. And so for the future one, we want to look at, including CMB drivers who operate between 10,001 and 26,000 pounds, because our CDL, it's only derived for CDL holders, but I bring that up because we had a really bad crash here last December in Searchlight, Nevada. Many of you probably heard about it, but it was a 15,000-pound vehicle, Arizona-based driver, and he killed 5 bicyclists just by running into them like bowling pins. You know, it was later determined that he was positive for methamphetamine. So we really want to be able to take those kind of sanctions at that level, not just at CDL holders. Plus, it'll help us with our expanded PRISM ideas in the future. So really, I just kind of wanted to see how this compares to your state laws and procedures. I looked at a few states, Washington being the one, and they I'll give them hats off. They got their CDL laws are written really well, and it was easy to follow. They're in applied consent as well, so it was difficult to try to piece it all together. But yeah, you know, I think that they have a great model for this going forward. But I just wanted to see how other states were doing it, particularly the zero tolerance states, because that's really kind of where we went with this. And then if anybody sees anything that we might have missed in this or any issues that they might see.
Great, thanks, Lieutenant Plowman, appreciate that. I know in the chat box, Trooper Chris Lynch from the Washington State Patrol mentioned that he had some comments. Chris, if you're able to unmute yourself.
Okay, so back in 2012, Washington legalized the use of cannabis for recreational use. And that was followed in 2014 by the legalization of sales for recreational use. So prior to legalization, we had a DUI law, which made it illegal to drive under the influence of intoxicating liquor, marijuana, or any drug, and also had that per se limit of 0.08. So once we legalized marijuana, we just put in a per se limit of 5 nanograms of THC. And at the bottom, there's a quote from one of our traffic safety resource prosecutors, and they believe that quite possibly in the future, like Nevada, we may lose the per se limit for THC DUIs. So since cannabis has been legalized in Washington, in the first year of legalization of sales, we had an almost 3-fold increase in the general population drivers testing positive for some level of THC at all times of the day and night. While in the first 3 months, there was a decrease in drivers testing over the 5 nanogram limit, and that rose back to about near normal levels by the end of the first year. And that 3-fold increase in general use of THC in drivers is mirrored by a similar increase in Washington CMB drivers being placed out of service for having drugs in their system between 2012 and 2017. Unfortunately, the classification of drug used by the CMV driver is not given, but it shows a similar trend to the THC use in the general population drivers. And between 2016 and 2020, we had a quadrupling of marijuana violations for CMV drivers. And also telling is the number of marijuana violations as a percentage of the total drug violations rose from about 50% to about 75%. So THC use has been steadily on the rise since the legalization. So what have we done in Washington to change our laws? We had the under influence prong and the 0.08 prong. And after legalization, we just added per se limit language of 5 nanograms. We also had a separate driving a CMV with alcohol in your system law. And this may differ from what Nevada has got. And I think it was more like what Lieutenant Plowman was aiming for with their zero tolerance standard. So what that did was place drivers out of service for 24 hours. It was also a gross misdemeanor, which tied the criminal nexus to the licensing sanctions. So once the marijuana was legalized here, we just, again, very like the DUI law, we just added that THC language to it. So sticking with that, driving a CMV with THC in your system law, you can see that the licensing consequences for the violation result in a 1-year disqualification. And that's for a refusal of a test of 0.04 over of alcohol or any measurable amount of THC in the system. And a subsequent violation, the driver would receive a lifetime disqualification from driving a CMV. So a trooper's left with a couple of choices. If they believe the driver's under the influence or affected by THC, they'd simply arrest them for DUI. Or if they have reasonable grounds to believe that they have alcohol or THC in their system, they would make the arrest for that, driving a CMV with THC in the system. So which one should an officer choose? You can see both the DUI and THC in the system are gross misdemeanors. They both have 1-year disqualifications from CMV driving privileges, but it's plain that the DUI law has more teeth and may offer more to reduce impaired driving recidivism through increased deterrence. And on the 4th DUI, it's a felony. But let me give you a quick example of when an arrest might occur under the THC and system law rather than a DUI. Say a trooper's called to a collision scene and that driver's already been transported to hospital, or he could be backboarded in an aid car. The trooper may be hard pressed to establish probable cause for impairment. He might not be able to perform SFSTs. But say later, drug paraphernalia is discovered in the driver's cab. Now that troop might feel that he's reasonable grounds to believe that the driver might have drugs in their system. So if he's able to execute a search warrant and it comes back that the driver had any measurable amount of THC in their blood, then we're back to that gross misdemeanor and we're able to remove that driver from behind the wheel of a CMV for at least a year. So sometimes it can be used when there's an inability to establish impairment, but safety is still served. And at the end of the day, that's the ultimate goal. But if in this state, if there's any impairment at all, it's a DUI arrest every time. Now, some of the roadside strategies we've come up with, because those search warrants are cumbersome and very time consuming, as electronic DUI packets, electronic search warrant applications, and that just helps streamline the process of DUIs requiring a blood draw. The other thing is some of the local agencies are starting phlebotomy programs so that their officers can draw the blood at the scene and save an awful lot of time by that. So to address a couple of Lieutenant Plowman's strategies directly, Washington State did adopt CFR 392.4 into our statutes, and that's the language that prohibits the use or possession of Schedule I drugs by CMV drivers, but we still have those two separate laws that specifically mention THC without linking to the federal schedule. So we're not relying on marijuana remaining a Schedule I substance. And we did define a CMV as a vehicle having a gross vehicle weight rating of 10,001 pounds or more. So that gives us access to all those hotshot drivers and box trucks. And just I know Lieutenant Plowman mentioned they want to see complete impairment, but again, here in Washington State, we don't really parse levels of impairment. Any impairment results in a DUI arrest. And I hope that's helpful.
That was great, Chris. I really appreciate it. Actually, if you wouldn't mind, if I could get that slideshow, that'd be awesome.
Oh, you bet. I'll get your email from Dr. Lance and send it to you.
Perfect. Thank you much.
Yeah, if you don't mind, Chris, we'll probably just go ahead and post it on the site so in case anyone else would like it as well. Do any other states have any comments? Go ahead.
So New Mexico is new to the game on now legalizing marijuana. And I guess my question is, I've heard a lot about the impairment of what we're going to do with CDLs and stuff. But one of the things that we've just been recently tasked with in my working group is the enforcement aspect of it roadside or at the port of entries. So we all know under 392.4 that it's still a scheduled, and it's part of that, part of the federal regulation. Now, when we passed it in New Mexico, we still adopted 392.4. So I guess I'm looking more for guidance because we have to send out directives, because now you'll have marijuana, and I grant the possession of it's probably not the majority of what we will see. But my question is very specific. What is the guidance you have sent roadside for the enforcement when they do have personal use? Because we know that it's a 24 out of service as long as they're not impaired. But do we seize the marijuana? How are you seizing it? Because it's now no longer a violation of state law in New Mexico or in some other states that have it as personal use. So I guess I'm kind of looking for guidance on how we would send that out to our inspectors and our officers.
Yeah, I think that's a great question. And we struggle with that too, as far as the possession part, but we're able to book it in just because it is a federal offense, and that becomes the evidentiary part of it. But you did bring up a good point. One of the things I talked to CHP, and he worked in the commercial vehicle section. He's a DRE, very involved in the A-Ride part. And one thing that he brought up was, they are all about their statement to the full impairment standard. So, and for commercial people, they understand that, hey, you can put them out of service. But he said there are times where, your normal traffic officers that stop a truck late at night, they're nowhere near an inspection facility, and they're doing field tests on these guys. They know they're under the influence, but they didn't meet that impairment standard to arrest for DUI. So they're letting them go. And, but it's not any real fault to them, because if they're not certified, they can't even put them out of service anyway. And the reality is putting them out of service, what's that really gonna do? Because you're just kind of leaving them on the side of the road. We really have no way to know that after their 24 hours, if they don't still have it in their system. They might still be so anxious from the stop that they ate a couple gummy bears and cooled down while they're in the cab for 24 hours. I don't know, but those are great questions, and we really have to change our procedure on how we do this. And I really like what Chris had put out as far as that format, because if we're going to go for just for a licensing sanction portion of it, because we don't feel it's going to meet necessarily a DUI standard, then we need to come up with a process on how to handle that. But like I said, this stuff just came up so quick that we didn't have a chance to prepare for any of it.
Does anyone else have any comments? Thanks, guys, for sharing that information. At least we have, so it looks like we have some points of contact and ways to continue to stay in touch as you work through it.